guys, welcome back. The topic for today's video is anticipatory bail. We're going to be doing a series of videos on bail, including bail by magistrates, by high courts, cancellation of bail, anticipatory bail, etc. And this is the first video in the series. If you want to watch the rest of the videos, be sure to hit the subscribe button so you get notified of our new videos. Let's start with the video of the day. Today we will be dealing with all facets of anticipatory bail. The law dealing with anticipatory bail can be found in section 438 of the Code of Criminal Procedure. Let's start with the meaning. Anticipatory bail means that once a person is arrested, he or she will be released on bail immediately, without having to go through the regular bail procedure. A lot of people have the misconception that anticipatory bail means that there will be no arrest, which is not the case. It only means that on arrest, the person will be released immediately. The essentials for anticipatory bail. Section 438 of the Code of Criminal Procedure carves out the essential for filing an application for anticipatory bail. What are these essentials? Let's find out. Number 1. A person should have a reason to believe that he or she will be arrested. This reason to believe can vary. It may be an FIR in a case, or a fight, or some other reason, but there must be a reason to believe that he or she will be arrested, without which the anticipatory bail application will not hold in a court of law. Second, it is essential that he or she anticipates arrest for a non-bailable offence. If you don't know what a non-bailable offence is, we have covered it in our previous videos and I will link it in the description box and also on the screen. Coming back, it is essential that he or she anticipates arrest for a non-bailable offence. Hence, such an application cannot be made in cases of bailable offences, rather only in non-bailable offence cases. Number 3. In such a case, person has to make an application to either the Court of Session or the High Court, though the convention requires that first the person goes to Court of Session and only then an appeal to High Court. However, we should not forget that the section gives concurrent jurisdiction to both Court of Session and High Court, but convention says go to Court of Session first. Let's move to the procedure for anticipatory bail. On filing of an application, the court will take into consideration the various facets, like the nature of offence in which the anticipatory bail is applied for, or the possibility of the petitioner absconding, or the antecedents of the petitioner. After that, the court may reject the application altogether, or grant anticipatory bail, or do neither and fix a day for hearing of the application after giving notice to the public prosecutor and the superintendent of police. After these formalities, the court on the final day of hearing may grant conditional or non-conditional anticipatory bail, or may reject the bail application altogether. In case of rejection of the anticipatory bail application, the petitioner can be arrested then and there by the police for the very offence for which he was trying to secure anticipatory bail. Let's move on to the landmark cases. The landmark case in the anticipatory bail section is that of Gurbaksh Singh Sibia vs State of Punjab, which is a 1980 Supreme Court judgment. It was delivered by a 5-judge bench. In this case, the petitioner was Gurbaksh Singh Sibia, who was a Congress minister for irrigation in the state of Punjab, against whom many FIRs had been filed on corruption charges. And he filed for anticipatory bail in case of arrest. The Supreme Court in this case laid down guidelines for the grant of anticipatory bail. The court held that the power to grant anticipatory bail is an extraordinary power, but is subject to limitations in section 437 and 438 of the CRPC, or the Code of Criminal Procedure. The court further held that in cases of public interest like corruption by the executive or crimes which are punishable with death or life imprisonment, this power of anticipatory bail should not be exercised. The court maintained that While deciding the applications for anticipatory bail, the judges or the courts have to maintain a fine balance between the rights of the petitioner, the case in which he has applied for anticipatory bail, and also the expectation of the society. So, this power should be used very cautiously and with much prudence. This landmark judgment went on to define the contours of power under Section 438 of the Code of Criminal Procedure. Moving on to the next topic, the duration of anticipatory bail. What is the duration for which anticipatory bail is granted in case the application is accepted by the court? In earlier cases like Adhridaran Das versus State of West Bengal, which is a 2005 Supreme Court judgment, it was held that the anticipatory bail may be given for a limited time. But later on, in the case of Siddharama Lingappa versus State of Maharashtra, which is a 2010 Supreme Court judgment, it was held that anticipatory bail can be granted for the entire duration of the case, and that should be the norm. And that has been followed so far. The next topic, cancellation of anticipatory bail. Anticipatory bail, if granted, can be cancelled in certain circumstances, such as violation of the conditions of anticipatory bail or certain other extenuating circumstances. But the question is, who will cancel this application? The anticipatory bail, if granted by the Court of Session, can be cancelled either by the Court of Session or by the High Court. However, if the anticipatory bail in the initial case was given by the High Court, then only the High Court can cancel it, and the Court of Session cannot cancel that anticipatory bail, as was held in the case of Rizwan Akbar Hussain versus Mahmood Hussain. Another important point to note is that the anticipatory bail cannot be granted to a proclaimed offender, as was held in the case of State of MP versus Pradeep Sharma. Further, it is also an important point that there can be no successive applications in case of anticipatory bail. Once the anticipatory bail application is rejected by the courts, the petitioner must apply for regular bail on arrest. He can't keep applying for anticipatory bail. If you enjoyed this video on anticipatory bail, don't forget to hit the subscribe button so you can get notifications of our future videos on the entire bail series and many videos after that.